We are coming to you live, almost 4-second, 3-second delay from the law office of Alan Butel in downtown Las Vegas. Alan handles criminal defense and civil litigation and is a frequent guest on our show and donated part of his office for us to do the show from, which is great. This show is about guns, related political issues, and self-defense issues. Fired Up is on KSHP Radio, 1400 AM. On Sundays mornings. They repeat this show. If you miss any part of it, you can listen to it on the radio. And this YouTube broadcast, of course, is on now. And the advantage to YouTube is it stays up forever, so you can tune it in wherever you like. And as I usually say, you can look at things I said 3 years ago and how wrong they were. So that's the danger of YouTube. They stay up forever. My guest today is Don Green, attorney in Las Vegas, who's licensed and practices here in Las Vegas and in California. If you would, Don, a little bit of your background.
Okay, thanks. Bob, of course, it's a pleasure and an honor to be on your show. Again, my name is Don Green. You can reach me at dongreenlaw.com. My cellular is listed on the website, or you can just Google my name, Donald J. Green, lawyer and counselor at law. Bob, the substantial emphasis of my practice is criminal defense and gun-related issues on guns, both criminal, administrative, representation of federal firearms licensees. We do gun litigation in the sense that we challenge the validity of various gun laws and enactments on various grounds. And we have a very robust practice, and we do a number of denials of FBI of firearms applications with the FBI, and we do some work with the Bureau of Alcohol, Tobacco, and Firearms in representing federal firearms licensees. Thank you.
Yeah, one of the troubles that firearms owners have is they can't find attorneys when the regulations are such that they get denied a concealed carry permit or denied possession of a gun, and they want to argue that. Don Green is the guy.
Thank you.
Because those are all federal cases, so he can do all those too. It's pretty good. And he's rather tenacious about it. I have heard from prosecutors how annoying Don Green really is.
Thank you.
Which is a compliment. Anyway, if you have a question or comment on the show, you can send me an email at bob@firedupmail.com. The sign on the wall, I think it's working now. We've had trouble with that website, but you can call the number on there, 702-257-1060, and leave a message, and I'll call you back, and we can figure out whatever it is you need. We try to answer every question we get by email or text, so we do respond to everybody. If you send us an email to that address and it didn't go, call the phone number. I will get right back to you. There are several hundred defensive uses of firearms every week in the United States. This is my normal opening here. They're rarely covered by the mainstream media, so I always try to start with a few interesting cases for the background information of people who own guns, so you don't make mistakes. Some are good shootings, some are questionable shootings, some are just plain wrong, but the stories I pick all have some dramatic use. The gun owners should know that. We are a nationwide show. When we're talking about law instances that are not related to California or Nevada, we are telling you advice, hopefully, that will keep you out of civil lawsuits and keep you out of jail. But if you have a case you're actually involved in, you need to talk to a local attorney. If you're in California or Nevada, you can talk to Don Green, yes, obviously. In other states where Don is not licensed, then you would need a local attorney to guide what the law says. Hard to challenge the law when you're not a lawyer in that state, because they won't let you. Huh?
That's right.
Yeah. You can complain all you want, and they just go away. So we're trying to use opinions that will keep you out of civil lawsuits and out of jail is the purpose of the thrust of this show. The first two cases I picked this week are complicated cases, and this is going to take a little bit to go through, but it's really kind of important. This is the Star Tribune reporting back on June 23rd in Minnetonka, Minnesota. a dispute arose between two guys in a storage place where you can store cars and fix cars and so forth. It's a public mini storage that has a set area for cars. They got into a beef because one of them drove in and parked, and the one guy had a fancy Camaro or something that was all tricked out, hot rod kind of thing. The other guy had a Model A Ford in storage. One scratched the other one, and I don't really have a good feel on who was right and who was wrong, but it's a two-bit thing where you've got $100 damage to somebody's car. But anyway, an update just this week on 8/4. Now this is 3 months later almost. Investigators are backing up the claim of the guy who killed the other guy in self-defense. The shooter said he would probably be dead now if he had not been carrying a gun. Following strong recommendations from the investigator in Hennepin County Attorney's Office, said this week the 65-year-old, that's the one that came up with a gun, will not be prosecuted for fatally shooting this 58-year-old. I'm giving you a very shortened version of what happened here, but Police Sergeant Troy Dennison wrote in the summary of the department's 20-page investigative report they submitted to prosecutors, the physical evidence and the eyewitness recollections appear to confirm the 65-year-old's explanation of events. This is it basically. Late in the morning, both men happened to show up at the storage facility. The younger man started swearing at the older man in a revival of this rift they had 2 months previous over who scraped whose car. We're dealing with just a two-bit, and they both have insurance. There's no point. But anyway, it went off. The younger man started yelling at the older man. The female facility manager tried to intervene. She stepped in between them. The 58-year-old grabbed her actually around the neck and flung her into a wall. The 65-year-old then drew a handgun he was carrying and yelled at the guy to stop. The 58-year-old then pounced on the 65-year-old. The two men went to the ground. They're rolling around on the ground. The 65-year-old explained he was on his back and his gun that he had drawn was now pinned to his chest because the other guy was laying on top of him. At one point, the 58-year-old said, the 58-year-old, the violent guy, was trying to gouge out his right eye. And there's some really gruesome pictures if you want to look this up in Minnetonka, Minnesota. So at that point, the guy got him away and fired his gun. He shot the guy and killed him. He was pronounced dead at the scene. He said, I don't consider myself a hero. I just did what had to be done. The guy had attacked this woman and he attacked me. He's a retired refrigeration technician and did have his CCW. The police chief, a guy named Scott Borboom, also credited an exhausted and bloodied shooter with the property interacting with officers as soon as they arrived. He put his gun on the ground, kicked it away, and showed his hands when the police showed up. I love people that have training so they don't get shot by the cops. In this case, the shooter did everything right. Sometimes you meet a person that just goes nuts, wild, and he warned the guy. He yelled at him, get away from me, get away from her, step back at it. And he's pointing his gun, and instead of getting back, the guy jumped him. They attempted, at the point where he's trying to gouge the guy's eye out, and he's laying on his back with his gun pinned to his chest, obviously is great bodily harm. He's going to be blinded in his eye. I don't think any jury would find different. He did it exactly right. This is now after 2 months, and a very friendly police department who looked at this and wrote a 20-page cover sheet to their file, which is, the file's got to be 8 inches thick. Sure. Because of all the interviews. When the fight started, a lot of people came over and looked at it and so forth. So he did it exactly right. He's still tied up in litigation. And of course, the family of the dead guy is trying to sue civilly now over nothing. And the point of me running this story is sometimes these things make no sense, and you end up shooting a guy, and all you want to do is go, here's $200, fix your car.
Right.
Yeah. It's just some people don't heed warnings and are irrational, and there they are. I mean, just
Yes. And here, two facts stand out. The 58-year-old pounces on the 65-year-old in defense of another, and the 58-year-old is gouging out or attempting to gouge out the eyes of the 65-year-old. The 65-year-old, of course, is pressed to the ground, or the bodies are together so they can't get the firearm right away. Again, this example has played itself out for over 2 months. The time point of the investigation is important here. Notice that the 65-year-old man who shoots cooperates with the police, probably gives his full story. Now, many attorneys, and including myself, will tell you, just say, look, I shot in self-defense. I was in fear for my life, for my children. He was raping the woman who was in the parking lot, I mean, the parking space right next to me. I know this woman. She lives down the street from me or whatever. But the thing is that cooperation, coupled with the facts which support the older man, he's the same age I am, the older man's version, and notice that the older man did not leave the scene.
right.
By contrast, I have two cases similar to these. Both of them, not one of them called 911. No one called 911 except the victim who was not shot. In those cases, one ends up criminal charges after 5 months of investigation. The second case is still pending from the beginning of July, and here it is near the middle of August. But you have that situation, great bodily harm, gouging the eyes, pouncing on him. He's possibly a protected person because he's 65 years or older. But again, key point is the time it took to investigate this case. It's not like you see on TV, and it's not like at a concealed weapons class where you say, okay, the scene's going to be active and then it's over. It's not. It's going to continue for weeks, if not months, and one of your examples, possibly even a year.
Yeah, it's you just feel so sorry for this guy that he's going through all this stuff because he has this wacko that you know, sometimes you just can't calm them down by pointing your gun and saying, don't move, I've got a gun, go away. If you pull this story up in Minnetonka, Minnesota, it took place on June 23rd. This is like 50 pages it has the whole police report and everything if you want to read it, but it's sometimes there is no choice. Quick commercial for Grant Defense, 5580 South Decatur. That's Russell and Decatur. They manufacture here in Las Vegas AR-15 rifles in several grades and versions, and a really great custom conversions of Glock pistols for carry. I would suggest you to take a look at their wares. They're open regular business hours. They're right where the Dewey Animal Shelter is. Their back door actually runs into the front door of Dewey Animal Shelter, so you can get there. Take a look, and you will find there are very nice guns. I'm impressed with them. This is KTVB, which is TV7 in Twin Falls, Idaho. This was earlier this month. This was 8/5, August 5th. Another long involved case. Police and the Twin Falls County Prosecutor's Office have concluded the man acted in self-defense when he fatally shot another man at the Creekside Trailer Court in May. The original dispatch was May 26th to a trailer park at 146 Addison Avenue West, if you know your way around Twin Falls. They got a call to report a man had been shot. An investigation found that a 45-year-old man shot a 38-year-old during an altercation outside the older man's home. Sounds like the other case. One guy's a few years older than the other guy. Different, though, of course. Police say they found the 38-year-old went to the trailer park with another man and a teenage male to confront the 45-year-old. They said that during the confrontation, the 38-year-old attacked the 45-year-old, basically jumped on him, who then fatally shot the attacker. After extensive review of the evidence, police and prosecutors concluded the resident acted in self-defense under Idaho law. There's a quote from the Twin Falls County prosecutor. Said, a person has a right to use deadly force when he reasonably believes that it is necessary to defend himself, his family, or other persons, or his home from attack. Of his home from attack would require a law degree to explain what that one is. But anyway, we concluded that after looking at all the evidence that this was what happened in this case, that it was legal self-defense. The Twin Falls Police Chief, Craig Kingsbury, said the event is an example of several poor decisions leading to a tragedy. Our agency investigated this event thoroughly, and the evidence supports that the resident acted in self-defense when he shot his attacker. The Twin Falls County prosecuting attorney was consulted every step of the way during the investigation. This seems like a normal case, nothing else going on. It's just, there it is. The three guys show up to recover a debt or something. Well, except the shooting was self-defense, but the shooter now is charged with illegal possession of a firearm because this was apparently a drug deal. Depending on why the shooter is a felon, we'll leave that. This may not be a drug deal. I threw that in, and that's probably not the case. But they're fighting over money or something. But it turns out he makes a legal shooting in self-defense, so the murder charge isn't there. The attempted murder charge, whatever, is not there. But he's still charged as a felon for felon possession of a firearm, and he's going on trial very shortly for that. We've seen this case over and over, this part of this case, where somebody is a prohibited person and they use a firearm to defend themselves or others. And what happens? Part of it, my best guess, I'm going to leave the details to Don, is if he's a serious felon, that is, his felony is for, a murder or drug something, or some serious felony charge, that they're going to go ahead with that case. If it's not, if he wrote a $200 bad check when he was in college, which of us didn't, he'll get a slap on the wrist and they'll let it go. But this guy needs a defense attorney, and hopefully he didn't make so many statements to the police that he buried himself, because this is a felon possession of a handgun. He could be in jail for a long time.
Sure.
Yeah,
10 years in federal court.
And if they really want him, they'll turn him over to the feds.
Right.
And the feds have no mercy. I just, if you need to defend your life, you need to defend your life. So you defend your life, and if for some reason you're not allowed to have a handgun and you had one, you're going to go to jail when you defend your life, because you're going to get charged with felon possession of a handgun. So
yes.
This is why you need an attorney when you get involved in a shooting, even if you're right. There are little details here and there, and why you should not explain the whole case to the police when they arrive.
Right.
Say who you are, and that's my gun, and that's the dead guy, and I shot in self-defense. I'd like to talk to an attorney. And they'll stop asking you questions right there. In the details of this case, he may have said something that, what do you think?
Well, I want to go to the point where the prosecuting attorney states the law of Idaho, where if someone reasonably believes, or there is a right to use deadly force when the person reasonably believes that it is necessary to defend himself, his family, or other persons, or his home. By contrast, in Nevada, we have like 3 or 4 statutes which would apply in this case. Deadly force can only be used where there is an imminent threat of great bodily harm or death to you, your family, and then you can't be the original aggressor. Then there's another competing statute which says if you try to avoid the situation before striking the deadly blow, whether it's the firearm or you used a knife, and it was more than bare fear. So our Nevada viewers and our Nevada listeners have to be very careful, because in my office right now, we have a situation where 2 different people, one is a quasi road rage where the perpetrator walked from his car in the middle of the intersection towards my guy's car with no weapon visible, but my client openly displays the weapon outside of the vehicle. He's arrested later. The second incident is where my client is driving down in a gated community and the street is blocked by a large U-Haul type moving van. And as he approaches it, 3 individuals approach his car. It's a Sunday morning. He's nervous and he takes out his weapon and lays it on the console. Case is still under investigation. Will charges be filed? I think unlikely. But in both those instances, was there fear of great bodily injury or death, which was more than bare fear? And I think that the Idaho statute, and I think that the California listeners, California viewers, Nevada listeners, Nevada viewers should be very, very cautious about this particular instance, because Idaho law seems to be different from
Yes.
Nevada law and definitely from California. Of course, the fact that the shooter may have been a felon, that's why people come to me when they have these problems, because maybe there was a defense of necessity to use the weapon, and that would be a jury question to present and let the jury decide of whether he possessed that firearm. Now, it was probably interstate commerce. They have that. He did physically have the weapon, but there may be a good instruction which could be developed for this man for necessity. What detracts from that, as you pointed out, was this a botched drug deal?
Yeah, I don't think it was. I think I read that into it, and I'm thinking of another case. But they don't really go over why the 3 guys who showed up were trying to get money from the 45-year-old defendant. We have 3 guys show up. One's the 38-year-old who actually attacked the guy. There was another male with him who ran when this thing started, and an 18-year-old or 17-year-old who was with him too. So there's 3 guys, and they're yelling at him for whatever reason. We'll presume he just owed him money, or whatever. It was a money transaction. I had a case years and years ago that was a felon in possession of a firearm, theoretically, where a security officer who's unarmed, there was an attack in the building he was in, and without going into all the details, somebody was driving through the building in a truck trying to run over people, literally, and he ran to the locker where he knew the other guard who worked later in the day kept his gun, and he was a prohibited person. The security guard couldn't have a gun. So he broke into the locker, got the gun, and as this guy was literally running over people with his truck, he shot him through the windshield, killed him. And that was not prosecuted because in the accident circumstances, if he's a felon, he was saving somebody's life that was in danger right then. And that was fine. But the details in these are so different. It's just a half a second difference in timing, or the statute, the way it's read in that particular state, or the way it's enforced, gets some serious stuff. This guy, I want to say at the end of this, when the police arrive, tell them what happened. Don't tell them why it happened. Leave that part out. I was thinking that this, so I don't. I shot the guy. Not, well, I thought he had a gun. Turned out he didn't. You know, you don't want to say stuff like that. Why did you think he had a gun? Well, you know, no. That's stuff for your attorney to explain to the police, not for you. Just tell them what happened, not why. Commercial, Jerry Creed, attorney at law, does firearms trust, class 3 firearms trust, and he has free consultations. His office out in Summerlin, 702-806-7777. And Jerry's out there. If you have a class 3 trust or a firearms trust, have somebody look it over. The laws are getting much easier in some respects. ATF's being more cooperative. In other aspects, they're being less cooperative.
Yes, he's the man.
If you've got a firearms trust you wrote a year ago, you need to have Jerry Creed look at it.
We just referred two trusts to him, one trust related issue, one gun trust related issue. In the past 30 to 45 days, clients report back to me very pleased at Mr. Creed's discussion with them, his knowledge of the law. And as you point out, if you got a gun trust that's before, now I don't do gun trusts. We do what happens if your gun trust really goes bad.
Yeah.
If you're sitting in jail, as you're sitting on jail. But the clients report back that they're very pleased, not just because of the free consultation, but pleased with his knowledge of the field. And it is something that you do not want to do by yourself for like $99.99 on the internet. So
please don't. If you've got a gun trust or particularly a class 3 trust, either one, and it's all fits on 2 pages, it's not valid. My quasi-legal position. The laws have changed so much in who you can have as a trustee and at what time and this and that and the other thing. It is just ludicrous. With just the boilerplate pages, if you got 2 pages, you need to have Jerry Creed fix it. This is the Washington Post reported on the 3rd of this month in Fairfax County, Virginia, actually, that no charges will be filed against a man who shot a 17-year-old in self-defense during a robbery last year. Sounds pretty straightforward. At around 10:30 p.m. on September 7th last year, 2016, officers responded to the 9700 block of Hagel Circle in Lorton, Virginia, for a report of gunshots. They found a local 17-year-old suffering from gunshot wounds to his upper body, and he was pronounced dead at the scene. Fairfax police announced in a statement that they closed their investigation into the homicide last month after an investigation showed the deceased 17-year-old and an 18-year-old also from Lorton and another 17-year-old who the police did not name tried to rob this 18-year-old man. He's from Manassas Park, a little wealthier area, at gunpoint during an apparent drug transaction. The drug dealer they tried to rob, that would be an 18-year-old, who police did not release his name, shot the first 17-year-old in self-defense, according to the statement. Fairfax County prosecutors determined there was no basis for criminal prosecution of the shooter. The Lorton 18-year-old who survived was charged with robbery and is awaiting trial. I read this and my brain is going, what? We have a robbery in the midst of attempted robbery on a drug dealer. Guy has lots of convictions. He's a drug dealer. That's why they were there, was to make a drug deal. Now the drug dealer apparently has a right to self-defense when the deal goes bad and this guy attacks him. We have everywhere that I'm aware of a thing called the felony murder rule, which Don will explain in a moment. That if you kill somebody during commission of a crime, or anybody is killed during commission of a crime, the felony murder rule says all the parties involved are responsible. Yes. This guy is committing a crime. He's selling drugs. They get into an argument and he kills one guy. there is either some very serious information missing here, or I'm at a total loss why the Fairfax County Police apply self-defense to a drug dealer who gets into shooting during a drug transaction. That it makes absolutely no sense to me. And I'm gonna, when I put this on the internet in a couple of days, hit my AMLAM column, I'm sure I'll get some people from Virginia trying to explain the law to me. Once in a while it's an attorney and it makes sense what they say, but something's missing here. This can't happen anywhere that I'm aware of.
You're right.
This is nuts.
Right. The felony murder rule, as a general principle, and what is taught in all the law schools and as general principles of application throughout the United States, is that when there is a murder, a killing committed during the commission of an inherently dangerous felony, generally robbery, kidnapping, burglary, arson, rape, and possibly even drug deals, it would in federal court, the person who shoots is, of course, liable, but all those who are with him are also liable under what's known as vicarious liability and the felony murder rule, which is, felony murder is first-degree murder. So there are two ways to get this other surviving drug dealer, and the surviving dealer, can he now be charged with the shooting death of his associate, even though the shooting was by a supposed victim who himself was a drug dealer? Now, I admit that this is rather a bizarre situation. I think that in Nevada, I can almost say with 99.9% certainty that the drug dealer who shot would be arrested.
Absolutely.
In California, depending on where you are and depending on the circumstances, I would say there's probably about a 98% probability. So it's quite possible that in Virginia, that there is either a statute or a case from the Virginia Supreme Court which interprets one or more provisions of Virginia law which would allow this man to escape liability. I think your example is good, that all the viewers and listeners should be very cautious that if something is going on, for example, and you become involved in it, are you going to take that action and try to shoot somebody in the defense of others? Let's say you're in a store, you're in a fast food restaurant. I'm not saying you're going to rob anybody, but if you're doing something and something happens, can you become liable if something goes wrong? The answer is yes.
Yeah. I mean, the simple felony murder rule is two guys walk into a bar and hold it up, and the bartender shoots one guy and kills him, and the other guy runs away. The guy who ran away is charged with the murder of the guy that got killed, even though he didn't do the shooting, but his co-conspirator in the robbery caused the gunfire. They were committing a felony at the time, and we charged the guy who's running away with felony murder. And if there's a third one who's waiting out in the car to drive him away, we charge him with felony murder too. Once in a while he'll get off on that one. But if you're committing a crime and anybody involved in your conspiracy gets killed, you get charged with felony murder. That's a very simple explanation of 500 pages of case law.
A very good explanation.
But this is just can't happen. But it did. We are always talking about training here, and if you keep or carry a firearm, you must learn to practice and must learn and practice the safety rules and the rules of engagement. So many of these cases would not happen and not be the problem they are to the individual if they got training and when you can and when you cannot use your weapon. There's all sorts of rules about that. The store I used to run, the gun store in East Tropicana, still teaches their concealed carry class every Monday, Wednesday, and Saturday. Starts at 9 a.m. Call the gun store, 454-1110, 702, obviously. You can sign up online at thegunstorelasvegas.com. One long word, thegunstorelasvegas.com. And they will walk you through it. There's a minimal charge for the class. I think it's $75. That includes ammo and targets and everything for your qualification. It's the whole thing. The renewals are $55, I think. I'm not honestly keeping up, but I think those are the right numbers. And,
that sounds about right.
I go in there, collect my mail every once in a while. Anyway, if you got a gun in your home or you carry one, get training so you know what the rules are, so you don't do something that any lawyer looking at would go, my God, all you had to do was not do this. But you don't know the difference. So you get your training from television, where they shoot everybody all the time. And they solve the case in 54 minutes of airtime. And shooting somebody in real life is a life-changing event. You will never be the same again, even if they don't die. Okay, now, you had, Don, we talked earlier, you had something you wanted to bring up in this show.
Update on the California gun ban on the magazines?
Yes.
Okay, update. A couple of shows ago, actually on June 29th, federal judge in San Diego issues a brilliant ruling stating that California's ban on large capacity magazines was in violation of the Second Amendment and the takings clause of the Fifth Amendment. On the same day in Sacramento, a federal judge issued a ruling which says just the opposite, that California's large capacity ban was constitutional and did not constitute a taking under the Fifth Amendment. Now, the Attorney General of the state of California, just at the end of July, filed an appeal of the Duncan case in San Diego, which says the large capacity ban is unconstitutional. However, the federal judge in Sacramento issued a ruling just about a week and a half ago where he said that it is constitutional. That judge issued a ruling which says, I'd like the parties to submit additional briefing on whether I should hold off on my order to deny a preliminary injunction pending the appeal of the matter in San Diego, which I think is a really smart decision. And I think that the judge might be rethinking why he denied the preliminary injunction, because otherwise it is setting up a conflict between two federal courts in California. That is the conflict before the Ninth Circuit. Now, we all know that the Ninth Circuit is probably going to, well, there's a likelihood that it could reverse the decision in San Diego, especially based on a March 2015 case out of Sunnyvale, California, where the Ninth Circuit already ruled that a seller does not have a right to sell large capacity magazines. To be contrasted from the case in San Diego, just in the end of June 2017, where it said those who already possess large capacity magazines must by July 1st turn them into the police, sell them to an approved firearms licensee, or take them out of state. How bizarre is that? Oh, let's just take them to Texas and have my cousin hold on to them. Well, anyway, the judge ruled that law is unconstitutional. That's the latest update on these. We fully expect that this will be briefed fully, but to the Ninth Circuit, which issued additional briefing orders just a few days ago, and so the parties have until like September to start briefing.
If you own large capacity magazines and you are currently in California, now that didn't change. It hasn't changed the law yet. It's still illegal to import large capacity magazines into California.
That is correct.
and still illegal to trade them, to sell them to one another if they're already owned.
This law was for people who already own them.
Magazines. It didn't change. They can't give their magazines to another Californian. They can give them to somebody out of state or destroy them or turn them into the police. So I made the mistake during a broadcast once when I was in Los Angeles and California got its original assault weapon ban. I was there then, and you know, I made a flippant remark on the air that the line of gangbangers around Parker Center in Los Angeles, that's the LAPD headquarters, was all the way around the block with gangbangers trying to turn in their AR-15s and FALs and whatever. And I got several emails going, really? My God, it was a joke. Nobody who illegally has a magazine is going to turn it in. What's going to happen if this holds in California? They're going to create 300,000-400,000 felons. I believe it's a felony because if you have more than one.
That was one of the principal points which was made by Judge Benitez, who coincidentally was a Bush appointee who ruled against this law in June, and the federal judge in Sacramento who ruled saying that the law was constitutional was also a Bush appointee. So we have to go a little bit further into their background. The Sacramento judge went to Bolt Hall in Berkeley, and the judge in San Diego went to Regional Law School, California Western, which is a great law school in the San Diego area. That's the only rationale, that's the only justification that I can see for their decisions being so inconsistent.
Well, that hopefully there's a couple of other similar cases that are in other circuits that are headed for the Supreme Court as we speak.
Maryland.
So that Maryland case particularly, and that may well overturn that. It gets to the Supreme Court and they accept it. That may clear this one up. It'll become a moot point because the U.S. Supreme Court will say that's it.
Yes.
Then the question is, will the states obey that law?
Well, I've always argued, and I have yet to argue a validity of a Nevada statute on the Second Amendment. I always rely on the Nevada revised statute and Nevada decisional law as opposed to the nebulous Second Amendment, because our statute, our Constitution in Nevada is much clearer,
right? And
I think that we get more mileage out of it. Unfortunately, some of the litigation which has been filed in Nevada has been filed in federal court, right. And I'm not going to say, but they got the rear ends kicked simply because of the prevailing rulings by the Ninth Circuit.
And until that change, of course, we may have a different Ninth Circuit eventually, and it will still be part of it if they do the 12th Circuit.
Theoretically, yes.
Theoretically, if they do it that way, because the Ninth Circuit is a huge circuit, and the rest of them are much smaller areas, much smaller populations. So the Ninth Circuit has more judges because it's getting overrun with cases.
25, 30 judges.
And anyway. This is, let me see where we're at here, 5:53. WDIC TV Channel 4, it's part of the clickondetroit.com network, reported on 8/4 of 17, a mild-mannered musician and grandfather in Detroit just turned 61 years old this week. He also recently received his license to carry a concealed firearm, Michigan. Good. On Sunday morning near his home on Detroit's west side, the grandfather was at a gas station. I just wanted some coffee, so I walked down there, and he walked over to the gas station, and he's going to get some coffee. A 16-year-old would-be armed robber saw the 61-year-old was armed, so the teen tried to take his weapon. The 16-year-old robber stuck his gun in the grandfather's back, apparently thinking it was an older, easier target. The victim told the man All I want to do is leave. The robber responded, "You can't leave." The grandfather replied, "Okay, what do you want to do?" The grandfather said the teen was controlling him by pulling his own gun. So he pulled his own gun and shot the boy in the stomach. The teen picked up the gun that he dropped. He was armed. It was a real gun. He was sticking in the guy's back. And ran out of the store, limped out of the store. The grandfather told the media no way he was going to let an armed 16-year-old make him a victim. "I didn't shoot to kill, I shot to save his life," the grandfather said. "I got him up off me. I've never been through anything like this. I never shot a gun before." Makes you wonder how he got a CCW. But this is all new to me. The 16-year-old was arrested and charged with assault with intent to commit murder, carrying a weapon with unlawful intent, and the felony firearms violation. He's not old enough to have a gun. This is my comment here. The teenage robber, distracted by the visible firearm, tries to steal a firearm from the elderly victim. Apparently, the victim missed the concealed part of getting a concealed carry permit. It's much better if the bad guy doesn't know you have a gun. That gives you the advantage to surprise him. So if you got a permit, carry it concealed. Don't leave part of the gun sticking out or print it against your clothes.
Exactly.
Or the other thing. Caught in the position he was in. Now he's got his gun and he's in this restaurant. The guy sticks a gun in his back. What does he do now? He can't give the guy his gun. The guy's trying to take his gun. That would be worth more than the money in the register, apparently. So if he does that, then this idiot teenager has two guns and a whole room full of victims. So he has to do something. He chose well. He shot the robber before the robber could react. And this is a really tricky point here. If someone is pointing a gun at you and you have smoothly practiced drawing your gun, etc., so over and over, thousands of repetitions, and you draw and fire, you will fire before he reacts to realize that you've drawn a gun. You got about a 1 second delay, what we used to call, well, this is on cable, the oh shit factor. The guy's still going, oh shit, when your bullet hits him. He doesn't realize that you're drawing the gun until it's too late. The second smart move this guy did, I like this grandfather, he was let the wounded suspect run away rather than chase him.
That's
he didn't
right.
really run, he limped away. This is perfect. I expect this is going to be a very quick, no charges filed case. And I also expect that the 16-year-old's parents are going to sue the grandfather
More than likely.
for wrongful injury.
But Bob, in this case here, you put in your notes, what did the victim, older shooter, miss about the phrase CCW?
The first C.
The first letter is concealed. I can only tell you that I am not trying to be Mr. Concealed Weapons Permit instructor today, but from a legal standpoint, we made notes. Look in the mirror, because if you have a concealed weapons permit and a police officer sees that you are wearing t-shirt type material and there is an imprint of what appears to be a Glock 17, and the officer can read the serial numbers as they're impressed on your gabardine shirt or your t-shirt, you have a problem. I always tell my people to, I use the Kmart example of someone, a case I had of someone who was charged with inadvertent display when he sat down in the shoe department at Kmart between the shelves where you can sit down and put on the shoe, then you turn around and look at yourself. As he was bending over to get his shoe, and this is at the Henderson Kmart. It's so sad, the one that's closing on Racetrack Road. But in any event, as soon as he walks out of Kmart, there's like 3 Henderson police cars waiting to talk to him about the weapon. Now, that was a case where it was inadvertent. He received a citation, which was ultimately dismissed. But take a look at yourself. Use a jacket. And because there are people out there who are going to see that weapon, and if there's an altercation, if there's a situation, Defense is going to be that it really wasn't concealed. You're the one that's being charged. And remember, whenever there's a shooting, it's like you are the suspect, even though you may be perfectly innocent. And even though you may be perfectly innocent.
That's why you say, I'd like to talk to my attorney before I make a detailed statement. It just brings to mind, and I know I've mentioned this on the air before because it's so on point here. In my misspent youth, when I was a bailiff, we had a fella, one I recall specifically, that was charged with carrying a concealed weapon. And this is in Boulder City, and actually in the surrounding township, which is county. But the police officer took the stand and to the prosecution witness and explained that he was, walking through the mall or whatever it was where he ran into this guy, and said that I saw this gentleman who was seated here in the courtroom. That's the guy, and I saw that he had a gun, and I arrested him for concealed weapon. And the defense attorney said, Your Honor, may I ask a question here? Certainly. He said, Officer, how did you know he had a gun? And the officer said, well, it wasn't quite all the way in his pants, and I could see part of the handle. And even the bailiff got that one. And the defense attorney looked at the judge and said, Your Honor, move for dismissal. And Judge Miller, Vic Miller, great judge out there, says, bang, the case is dismissed. How can you charge somebody with concealed weapon when the way you knew he was concealing a weapon was you saw it? I mean, that's just, it's concealed or it's not.
Right.
This is like, it's one way or the other. It's not partially concealed, then it's not concealed.
That's right.
And it was just hysterical. Obviously, so this older guy is violating that same thing, but unfortunately, instead of a policeman coming up and saying it, a 16-year-old thug saw it.
Yes.
And away he goes. I want to talk maybe a little bit here about, because we're almost up on time right now. A brief note, Tim Schmidt of the United States Concealed Carry Association reported to USA Today, now it's okay for licensed gun owners to carry concealed handguns at institutes of higher education. That is colleges and universities, community college all across Texas, starting yes. Tuesday. The law, Senate Bill 11, was the campus carry law, went into effect last August, and so on. So anyway, it's a long story, but now all college, higher education students in Texas are allowed to carry their firearms on campus if they choose. And obviously they're waiting, the left side is waiting for all the shootouts and crap.
Right.
Which, we'll find out. We were waiting for all the shootouts when Arizona went to anybody can carry concealed if you're not a criminal.
Right.
And it never happened. My argument would be it'll make the campus safer because every girl who wants to carry one is going to shoot the guy who tries to rape her,
yes.
or at least point the gun. So we'll have some data from that in a year or so and see what happens. We've got some gun shows coming up. Western Trails is August 12 and 13. I believe that's this next weekend.
Yes. At
the East Side Cannery Hotel Casino. That's in Boulder Highway in Harmon. You will be there with the table, of course.
Yes.
I will hopefully be there part of the day Saturday at the NRA table. I'll come by and see you and bring you some stuff. Crossroads of the West Gun Show is August 26 and 27. I have some passes for that if you would like to get one. As I'm not at the gun store anymore, you got to send me a text or an email asking for one, or leave a message at the phone there. Give me your address because I'm going to have to mail it to you. I got several calls last show that said, hey, this is Joe. Can I get one of those permits? Click. Here, one of those passes. Tell me who you are so I can call you back. And then Claude Hall is being here at the Sports Center again, September 2nd and 3rd. We'll be there also, both of us. I've got a table there also. So next week, we've got firearms instructor and terrorism expert Lenny Davis will be with me. Always an entertaining guy.
Yes.
I saved some shooting cases for him just because they annoying. Last week I didn't have enough outline and we ran short, so now I'm putting 6 or 7 extra cases on every show, so I have something and don't get caught flat-footed. I will be on the radio 1400 AM on Sunday morning from 9 to 10, a rebroadcast of this show, and we'll be here next week with Lenny Davis.
And before we go, Bob,
Yes.
I want to present to you, we have a new item from my office. I want to present to you the very first, this is the proof of a card which has the 2017 Nevada revised statute of all 30 states, which Nevada will now honor for their CCW. This is the proof, the very first, and I want to give it to you.
Oh.
And if your listeners want to call, either call me or go online to dongreenlaw.com and go to our email, we'll be more than happy to mail them out a card. And I'll give you some extras. And you have the first one there is the proof. And Sandy pulled that out, and I have that over here. Actually, excuse me, this is the proof from my notebook over here. So you have the very first one.
Well, that's very nice. A handy gadget to have when you're traveling.
Now, 33 states honor Nevada, but Nevada only honors 30.
Right. And hopefully that's being corrected. We're having discussions about the bills in Congress to require national reciprocity. I have taken several stands against that it needs to be national constitutional carry rather than letting the federal government run the reciprocity program, but that remains to be seen. I've got some of the big gun people on my side. The NRA is against it. They want national reciprocity. I think that's the Lawyers Full Employment Act.
There it is. Yes.
Yeah. Anyway, if we have national concealed carry that is allowed under the Constitution, constitutional carry, what are all these gun groups going to do?
And who's going to enforce it? ATF? Possibly.
They would be the one, I would think.
Yes.
I don't think the FBI wants to take that on. So anyway, we're right on time. We'll be back next week with Lenny Davis. Thank you one more time for being here. Always entertaining.
Thank you.
And we'll be back next week at this same time or thereabouts on YouTube. Thanks for listening.
Thank you.